into the presentation. So the agenda for this session today, which should take us about an hour, covers sort of 7 areas: recent context regarding defects, building pathology, contractual principles, some contractual provisions, a few discussions regarding the quantum issues surrounding defects, a little bit on defects avoidance, and also the role of a technical expert, which is in effect what Ewan does on a day-to-day basis. So I'd just like to hand you over to Ewan to give his part of the presentation now. Thank you.
Thanks very much, Damien. And firstly, good afternoon, and thank you to everyone for attending. If nothing else, it's given me a chance to wear a work shirt for the first time in 5 or 6 weeks. So that's definitely a plus. And I hope you're all keeping well in these strange times. As Damien said, my name is Ewan Geddes, and I'm one of the architects in the buildings team at HKA. My background is in commercial architectural practice, where I worked as a director of a large practice until about 2 years ago. Since then, I provided expert opinion on a variety of architectural matters, including failures in design, specification and construction. I've also provided opinion on professional negligence cases, both in my work at HKA and also wearing another hat. I'm a member of the investigation panel for the Architects Registration Board, and they're the regulatory board for architects in the UK. I'm going to look at defects from the perspective of a non-legal technical expert. I will refer to relevant case law, but please bear in mind that I'm not a lawyer. So I'm going to just put my camera off while I get into the presentation, if that's okay. So before getting into the technical and contractual aspects of building defects, I thought we might first consider the question, why is this actually important to us? Isn't it just an accepted and normal in the building industry that our buildings will be defective? And I think perhaps the best way of illustrating why this is important is by looking at recent examples of buildings or projects which have gone wrong. In doing so, we'll see that there are 3 main issues associated with building defects. Firstly, there's the health and safety of those in and around the buildings. Secondly, there's the financial ramifications for the people and organisations who are procuring buildings. And thirdly, there's a loss of availability of the buildings for the purpose which they were intended. The examples that I've picked are all in the UK, but I think the principles apply to construction projects throughout the world. And in other words, they're far from unique. So the first example, the Edinburgh Schools project. During a storm in early 2016, part of the external wall of a school building in Edinburgh collapsed. The building was one of 17 buildings constructed under a public-private partnership, or PPP. And as you can see in the photograph, there was approximately 9 tons of collapsed masonry. Fortunately, no one was injured, and this was really just a matter of luck and timing. The collapse happened at 8 AM before the school day had properly started. Following the initial investigations, it was established that there were fundamental construction issues with the external leaf of the masonry. And it was subsequently established that this wasn't an isolated incident. It affected all 17 schools built under the procurement agreement, which were built by a range of contractors and a range of subcontractors, so common defects. Critically, the inquiry exposed failures in procurement, design and construction. Were the problems restricted to the 17 Edinburgh schools? Well, Professor Cole, the report's author, didn't think so. He said it was neither restricted to Edinburgh or school buildings. He was proved right. Firstly, the defects were found at 72 more Scottish schools. They later found that the same thing was happening in Northern Ireland. And then, very shortly after, they found that there were similar defects in a building in Dumfries in Galloway, which is the subject of the next case study. DG1 was a leisure centre building in Dumfries, which is in the south of Scotland. The building failed comprehensively after only 4 years in operation. It was then shut for the following 6 years. And Professor Cole, when he prepared his report, said that there were serious defects permeating virtually all elements of the building. However, there's one really remarkable thing about this building, I think, when you look at it from a defect standpoint. It cost, the assessed cost for reinstatement of the building was £20 million, almost £21 million. The original cost to the employer was only £17 million. So it cost more to remediate the damaged building than it actually cost to build it in the first place. And the final cost to the employer was estimated to be £33 million, almost double the original budget. That was with a contribution of almost £10 million from the building contractor. So the next study almost needs no introduction, I'm afraid. The disaster at Grenfell Tower in June 2017, it was a high-profile failure which resulted in 71 deaths. Aside from the human tragedy, the case has been extremely important to the construction industry. It's given rise to an independent review of building regulations and fire safety, which many of you will know as a Hackett review, and also an ongoing public inquiry. Phase 2 of the public inquiry, which looks at the cause of the event, includes the involvement of design and construction teams and how their relationships led to the disaster. That phase of the inquiry started before the COVID-19 lockdown, and the panel is currently looking at how to continue its work. Even at this early stage, it's evident that the fragmentation of design and construction processes contributed to the disaster. Indeed, at the start of phase 2 of the inquiry, Council asked the core participants not to indulge in a merry-go-round of buck passing. What was the result of that? Well, this is a simplified matrix of who was responsible for what and who blames who. It highlights in a rather extreme way one of the main problems with the investigation of building defects. Who's responsible for design and who's responsible for construction? Due to the increasingly complex ways in which we now procure buildings, this is becoming less and less clear. The final bit of context is a government, an all-party group was formed by the UK government to look at more homes, fewer complaints. They wanted less defects in buildings. That was published originally in 2016, and it was followed up by a supplementary report in 2019 entitled New Build Housing, Construction Defects and Solutions. The reports were sparked by a growing number of complaints about defects in new build housing. And I think the findings of both the reports were really quite sobering. The quality of housing in England is bad and getting worse. And there are too many reports of uninhabitable houses, new build uninhabitable houses, with 93% of buyers reporting defects to the builders and 35% of them reporting 11 or more defects. So that's the context in which we're operating at the moment. So from these examples, we can see that building defects have both life safety and financial implications. Building pathology gives us a way of investigating these defects. Firstly, what is a defect? Although there's no standard definition, they can generally be categorized as a failure of design or construction and a failure to build in a reasonable and workmanlike manner and or in accordance with a contractual provision or specification. There are a couple of historic cases which give us some guidance about this. In Tate v Latham and Son, which dates back to 1876, it was noted that a defect was a lack or absence of something essential to completeness. And then shortly after, in Yarmouth v France, it was held that a defect is anything which renders a plant, or presumably a building for that matter, unfit for the use which it is intended. So what are the reasons for defects? Defects can broadly be categorized or broadly be caused by in 5 different areas. The design can be inadequate or defective. The construction which is not in accordance with design or specification. Materials which are used are incorrect, inadequate or faulty. The works don't meet the stipulated performance or output requirements. And finally, the works might not have been constructed in accordance with good practice. It's also important at this stage that we realise that defects can be either patent or latent. The way that each of these categories is handled under a construction contract is markedly different, so it's extremely important that we're able to distinguish between the two categories. So a patent defect is detectable. That's the main thing to note. It's detectable. However, it may be unseen to a casual observer, but it's capable of being discovered by a skilled person or with the advice of a skilled person. This was explained in the case of Sanderson v National Coal Board in 1961, where it was held that the natural meaning of the word patent is objective, not subjective. It means observable and not observed. A patent defect must be apparent on inspection, but is not dependent on the eye of the observer. It can blush unseen. A lovely bit of legal phraseology. In this case, although the defect was in darkness, it was patent. Had the plaintiff or his mate shone their lamps on it at the relevant moment, they would have seen it. So what that's telling us is that a patent defect must be apparent on inspection. It doesn't actually matter if someone fails to observe it or fails to look for it. It's enough that the defect is discoverable had someone chosen to look for it. That's to be contrasted with latent defects, which are concealed and may not manifest themselves for years. Bear in mind that a defect is not latent just because it is undiscovered. If it ought to have been discovered, then it is simply a patent defect which has not been identified. Again, there was some legal guidance provided in this in the case of Baxel Securities v Sheard Walshaw Partnership in 2002, where it was held that the concept of a latent defect is not a difficult one. It means a concealed flaw. What is a flaw? It's an actual defect in the workmanship or the design, not the danger presented by the defect. To what extent must it be hidden? In my judgment, it must be a defect that would not be discovered following the nature of inspection that the defendant might reasonably anticipate that the article would be subjected to. So, in layman's terms, a latent defect is a concealed flaw which will not be discovered during the normal course of inspection. So that's the difference between latent and patent defects. Before we get into Damien's part of the talk, in terms of contractual provisions, it's probably important that we also look at some of the basic contractual principles that are relevant to the assessment of defects. First and foremost, practical completion. Practical completion, or PC, it's a recurring theme in construction disputes. And I suspect that's probably because, firstly, it's got significant contractual, financial and practical implications for both parties. So amongst other things, it marks the point at which the building is handed back to the employer, and also the contractor's liability for liquidated and ascertained damages ends. We could talk about the contractual significance of practical completion in an hour-long talk on its own, but I think it's broad principles we're talking about here. Secondly, and perhaps more problematically, it's not a contractually defined term. Although it's understood to be the point at which the building can reasonably be used as intended, this means different things to different people. Most notably, it means a different thing to the employer and the contractor, who have entirely different takes on this. Given this, the decision to issue a certificate of practical completion requires critical judgment rather than strict compliance with the definition. It needs a thorough understanding of the employer's requirements, the specification, and the standards of workmanship being delivered by the contractor. Above all, it requires an impartial professional opinion. So, at this stage, I pose a fairly open question. Do contract administrators always understand their responsibilities in respect of practical completion? For example, if a project manager is acting as contract administrator, do they have sufficient knowledge of the design and specification to make such a judgment, given that they had no hand in the design and no hand in the specification in the first place? As an architect, you probably expect me to the answer that I'll give, which is I don't think they do have that level of knowledge of the project to make that decision. But that's not any disrespect to the project managers in the audience, that's a personal take. But I think it's suffice to say that whoever is making that decision about practical completion has to be familiar with the standards that they're trying to achieve. Again, there's some legal precedent that helps us in this interpretation. The case from last year of Mears v Cost Plan Services was important for a number of reasons, but they talked about practical completion and offered the following guidance. They said that the PC is often easier to recognise and define. There are no hard and fast rules. They also stated that the existence of latent or undetectable defects cannot prevent practical completion. under the contract, there's no difference between incomplete and defective work, and the work should be free from patent defects other than those which are trifling. In terms of trifling, what does that mean? Well, it's a matter of fact and degree to be measured against the purpose of allowing the employer to take possession of the works and to use them as they were intended. Although the caveat to that is just because a building can be occupied or used does not mean that it's practically complete. And finally, the last bit of guidance from that case was that a remediable defect does not mean that the works are not practically complete. So following on from practical completion, one of the things that practical completion does, as I'm sure most of you will be aware, is it starts the rectification period, or as I know from my training, defects liability period in old money. And that period is intended to allow a reasonable fixed period for defects in the works that become apparent after PC and to give the contractor a chance to remedy them. Technically, defects which are due to the contractor's failure to satisfy the contract amount to breaches of contract for which the employer is entitled to damages. However, in all of the contracts, typically defects provisions enable the contractor to remedy that breach and mitigate its exposure by avoiding the risk of the employer engaging a third party to remedy those defects and claiming those costs. Often the cost in that case will be higher than it would have been for the contractor to undertake the works themselves. Clearly, though, defects provisions in contracts don't cover regular maintenance of the building, which remain the responsibility of the building owner. The rectification period is ended by the issuing of the certificate of making good defects. And in the case of Swansea Stadium v City and Council of Swansea in 2019, there was discussion about the significance of the certificate of making good defects. And it held that the certificate of making good defects, it signifies that defects that are to be rectified are considered to have been made good under the contract. But it is still possible to bring a claim in respect of the core obligations of the building contract. At this point, I'm going to hand you over to Damien to look at some of the other contractual principles which are relevant to the assessment of defects.
Thanks very much, Ewan. Yeah, the first thing we're going to look at is contractors' rights and obligations. And as Ewan mentioned there in the first section, when we're looking at what a defect is, we often first look at the requirements of the contract and the specification. However, we have to bear in mind that works may be defective even if carried out with all due skill and care, and sometimes even in accordance with the specification itself. So we could have a situation where the contract includes a fitness for purpose obligation. A specification could therefore be met, industry practice could be followed, but the works are still defective and the contractor, unfortunately, is still liable for that. And the recent example of that scenario was the MT Hogard versus E.ON case from 2017. Many of you will be familiar with that case, which went all the way to the Supreme Court. But in summary, the grouted connections of wind turbines at two recently completed wind farms at Robin Rigg in the Solway Firth failed. But Hogard had designed and constructed the grouted connections in accordance with the J101 specification that was current at the time. Unfortunately, the specification did contain an error, which meant that the shear key to the grouted connection was not installed, and the grouted connection failed. Now, interestingly, the parties agreed the costs of the repair. It wasn't something that was decided by the court, and they agreed that the cost of the repair was 26.25 million euros, but the court was left to decide liability. And it went all the way to the Supreme Court, as I just said, and the court looked at the contract as a whole, and it did include a design life obligation of 20 years. And they ultimately therefore decided that Hogard were liable, even though they'd followed the practice and specifications that prevailed at the time the works were undertaken. Now, you know, what I take from that is when you've potentially got a fitness for purpose obligation, you really do need to look extremely carefully at your contract documents, and where there is referencing there to design life, are you taking the liability on for that design life, or are you in some way excluding that liability? So it really is a warning for contractors. In terms of returning to remedy defects, it's a common misconception that a contractor always has the right to remedy his own defects. In reality, it's whatever the contract says, it's the express terms in the contract that define your rights to return. Having said that, if an employer goes ahead and employs others without allowing you the opportunity to return and rectify your defects, then that might limit the monetary amount that he is able to recover from you. But we'll pick up on that in more detail in a couple of slides' time. If we could just move on to the next slide. Okay, so what if a contractor is notified of an alleged defect but does not agree that he is liable? How should it respond in those circumstances? I guess it's a difficult one. I mean, there's commercial aspects and there's also contractual aspects. What does the contract require you to do? Would you be in breach of contract if you didn't proceed to rectify the work, even if you didn't think that you were liable for it? This situation arose in the Scottish case, SSE Generation versus Hockteeth. This was a very, very difficult situation for all parties concerned. This was a hydroelectric scheme that was constructed between 2006 and 2008, and it was the biggest such scheme to be built in Scotland for many years, and it failed approximately 8 months after takeover. What had happened is that a collapse had occurred in the main tunnel, and rock material had been falling from the crown over several months, and this led to a blockage that was only actually discovered a few days after the Queen attended site to open formally the project. And obviously the parties had gone quite well up until that point, but this was a dramatic failure on a mega project, and the parties tried to negotiate for Hockteeth to return, but those negotiations failed, partly for financial reasons, partly I think because of a lack of trust. But interestingly, in the lower court, it was held that this was an NEC2 form of contract, and it was decided that the contract included in effect a standalone regime that obliged the contractor to return and effect repairs during the defects correction period, even if it disputed responsibility for the defect. In effect, rectify now, argue later. So, but they didn't, and another contractor were employed to undertake the rectification works, and it was went on for a number of years. It didn't generate electricity until August 2012. Now, the contract for the remediation works was an option E contract, a cost plus, and it ultimately was about £114 million to repair. But obviously at that point, Hockteeth were denying liability, and in the lower court they succeeded, and it was held that they had acted with all reasonable skill and care. There was a qualification, or option M, in the contract, which meant that their duty was only to provide reasonable skill and care, and the lower court decided they weren't liable. So in that context, maybe they were right not to have proceeded to rectify the works themselves. But in the upper court on appeal, it was decided that they were liable, and in that situation it was quite a nuanced point taken by the Court of Appeal. Really, they said although there was a design limitation in terms of reasonable skill and care, it was the implementation of the design, not the design itself, which was defective, and therefore their limitation of liability clause in option M didn't protect them, and they were liable for the full value, which was about 114 million, maybe slightly less, maybe 104 actually in the end. I did hear that at the time there was talk about it going to the Supreme Court, but it hasn't done. So I don't know whether there was a settlement or what precisely happened. But in those circumstances, maybe now with the benefit of hindsight, I'm not sure whether Hockteeth wouldn't have rectified the works themselves. So again, quite an interesting case, really. Next slide, please. If we now look at, what's the employer's duty to mitigate when defects arise? If an employer does engage a third party to remedy a defect, instead of allowing the original contractor to do so, it may be regarded as having acted unreasonably and failed to mitigate its loss. And that was the situation in those two cases there, Pearson High Limited versus Baxter and Woodlands Oak Limited versus Conwell. It's interesting, both those cases are building sort of relatively small building projects with private owners, which often seem to be the cases that are the most litigious in reality. But in terms of the Pearson Baxter case, the defects were notified after the defects liability period had expired, and the Court of Appeal stated that even if notified outside the DLP, a breach had occurred that could potentially result in damages. However, the right of the original contractor to return to site and rectify his own defects was very valuable to him, as the cost could be very little or nil compared with the cost of employing the third party. And therefore, the only cost that could be recoverable in that situation would be the cost to the contractor of remedying the defect, the original contractor, and the third party costs would not be recoverable. And in the Woodlands v Conwell case, that was a cost plus arrangement that was entered into. And again, when the parties fell out, they didn't afford the original contractor the opportunity to undertake and rectify his own defects, which he could have done at zero cost in reality, because he could have got his own supply chain to come back and rectify, and they didn't. So again, it was decided that in this instance, the employer was not able to recover the costs that he had incurred. But the Court of Appeal did state, though, that the failure to allow a contractor to repair his own defects may not always constitute a failure to mitigate loss. It would depend on the facts and circumstances of the case. So just because you are not allowed back doesn't mean that the employer wouldn't be able to claim against you. It would come down to the circumstances. So in terms of examples of why an employer may be entitled to employ a third party, even if the contract allows for the original contractor to return, would be listed there, which would be, for example, that the defects are so extensive that the employer has quite rightly lost confidence in the original contractor, or the contractor behaved fraudulently, or the contractor has made it clear that he's unwilling to return and rectify the defects. He may well have attempted to rectify the defects previously and has failed to do so, and therefore, in the circumstances, he should not be given a further chance to do so. He may well be offering a different solution that isn't acceptable to the employer and doesn't actually meet the requirements of the contract, or he may just be delaying excessively his approach to remediation. So there's no real one-size-fits-all approach in this. It would very much turn on the facts of the case. Okay, next slide. So now we're just going to briefly touch upon a few of the contractual provisions that relate to defects. If we first look at the JCT Design and Build Contract 2016, there are a number of different provisions that relate to the rectification of defects, including inspections. And I don't intend to go through every single clause that relates to defects, but the overall sort of message that I would want to put out there is that the provisions are extensive, and the rights of the employer to proceed and force the contractor to address the issues are quite extensive, And the same goes for a contractor against a subcontractor in the comparable JCT subcontract. And you will note there, for example, clause 3.6, non-compliance with instructions. If the contractor does not comply, having received a 7-day notice to comply, then the employer may employ others and recover additional costs incurred from the contractor. And that's quite a powerful tool. Having said that, in my experience, often parties wait. They're aware of defect issues, but they do not address it head on. And often it drifts up until PC and possibly even into the defects liability period, when the contract does allow you to grasp the nettle, so to speak, and move forward and get these issues resolved. And that obviously includes instructions to open up the works and further instructions under clause 313 when there's a perception or a concern that there could be further non-compliance as a result of the first inspection. Okay, next slide. In terms of the rectification period under JCT, in the contract particulars, if none is stated, it's 6 months, but usually, as most of you would know, it's normally 12 months. And the contractor has the obligation to rectify defects, shrinkages and other faults specified in the schedule of defects issued not later than 14 days after the expiry of the rectification period. But it also needs to be borne in mind that during the rectification period, the employer may also issue instructions to rectify if necessary. So he doesn't necessarily have to wait until the end of the rectification period to actually draw the attention of defects to the contractor. 235 talks about the contractor making good within a reasonable time, but it doesn't define what that reasonable time is. So therefore that can be open to debate. But the employer also has the option not to instruct the contractor to undertake the works in the defects rectification period. If he so instructs otherwise, as it's described in there, an appropriate deduction may be made from the contract sum. But again, it doesn't say what an appropriate deduction is. What does that mean? Well, the courts did look at that point, which I touch on on the next slide. And it was considered, this meaning of what's an appropriate deduction when the employer doesn't want the contractor to undertake the works. And it was considered by Aikenhead J in Oksana Mull v Hutton. And this was like a preliminary case on a point of law, really, rather than the whole case. But counsel for Hutton argued that the valuation of the appropriate deduction would invariably be by reference to the rates or prices in the price documents. At least this is important from their perspective, because they said the contractor has been denied his right to remediate the works, which for me makes sense, because it's the employer that's choosing for the original contractor not to do the work. So therefore, arguably, it's going to cost the contractor very little. So why not reference to the rates and prices to make that deduction? Seems to make sense. However, Aikenhead considered all the legal cases that had gone before and really decided that it could mean one or more of the following. So it could be rates and prices, it could be remedying the defects, the cost of remedying the defect, it could be the reasonable cost of employing another, or it could be factual circumstances or expect evidence as well. So again, no one size fits all, whereas from a contractor's perspective, he may well feel aggrieved if the appropriate deduction is something other than the rates and prices in the contract. Okay, next slide. Just touching briefly on NEC, it's unusual, the NEC, because it actually has a definition of what a defect is, which includes part of the works not in accordance with the works information. The problem with that, as we touched upon in the earlier slides, is that the works information may include performance requirements, and if these are not met, then arguably there could be a fitness for purpose obligation. So to protect the contractor, we do have option X15, which reduces the liability for design to reasonable skill and care. Again, there's a few more clauses there that relate to NEC. I won't go through all of those through this presentation due to lack of time. But what is interesting is clause 45 and clause 46 there really reflect the common law position, i.e. if access is provided but the contractor fails to rectify the defect, the PM assesses the cost of rectification by others, but if access is not provided prior to the defect's date, then it's the cost to the contractor of rectifying the defect, which makes sense. And that clause 82.1 there is in effect the clause that was considered by the courts in SSE versus Hockteeth, and this concept of rectify now and argue later. Okay, thank you. I know we've got a few people from overseas or on the call today, so I just want to touch briefly on FIDIC as well. Again, slightly different provisions. The interesting point from a FIDIC perspective is, the way I view it, is this idea that the defects notification period can be extended by up to 2 years if the whole of the works or a section or a major item of plant cannot be used for the purpose for which it was intended. So if you've got a really serious defect scenario, then it does afford the employer to extend the defects liability period for 2 years, which is an interesting provision that we don't find in JCT and NEC. Okay, moving on now to quantum issues. How do we measure damages when we have a breach, when we have a defective materials or workmanship? Well, if it's a breach of contract, the purpose of the monetary award of damages is to put the claimant back in the same position it would have been in but for the breach. Therefore, in most situations, if the innocent party has incurred its costs in the rectification of defect, it is those costs that are recoverable as damages, i.e. the cost of reinstatement. On the face of it, that all seems very straightforward, but it often is not the case. So when it comes to cost of reinstatement, the actions of the claimant may be relevant as to the amount of damages that can be recovered. So if you are in a situation where major rectification works are to be undertaken, then you really need to have the need for such works supported by independent expert evidence from someone such as Ewan, for example, as there are often extensive arguments as to the extent of rectification works that are necessary. And also from a commercial point of view, you may go out for 2 or 3 tenders to show that you've actually gone out there and got the best price and the best scheme to rectify the works, rather than negotiated with one particular contractor, for example. In terms of, what's the assessment date? Well, in a strict legal sense, the date of assessment is the date the defect is first noticed. But when you're claiming the cost of reinstatement, it's normally taken as the date when it was reasonable to undertake the works, which could be a couple of years later if you've got to get a new design through planning, for example, when there's a new cladding scheme. It can take quite a lot of time to get this defect scheme off the ground. And in exceptional circumstances, it may well be deemed acceptable to proceed to trial without having undertaken the remediation works, but that would be unusual. But certainly it can be, it can be some time after the defect is discovered. It's also important when you're quantifying the cost of reinstatement to value like for like. So if you've got enhancements in design and specification, you need to exclude those from the claim for damages. Loss of profits are usually recoverable, and overhead management costs can also be recoverable as well, provided that you've good records of the time spent. Interestingly, in the Bridge Abbey case, the managing, I think it was a managing director or director of the firm, kept his record, didn't have records at the time, but he wrote down his record retrospectively and worked out that he'd spent 120 hours trying to resolve the defect, and the court awarded 100 hours. So, that was a good example of where once the liability had been established, overhead and management costs were recoverable. In terms of if cost of reinstatement is not applicable, then diminution in value may well be the approach, which in effect is how is the asset being reduced by the breach. When we talk about loss in value, the classic case I suppose is Ruxley Electronics versus Forsyth, which was the swimming pool case, where the pool was meant to be built to a depth of 7.6 feet or 7 feet 6 inches at the deep end and was only 6 foot deep, and the claimant was looking for the pool to be replaced at about £22,000, and the court decided that there wasn't really a reduction in value anyway, and therefore all he was awarded was a loss of amenity of about £2,500. Next slide. We'll now touch on set off versus abatement. When it comes to set off, obviously that's normally the costs of employing others to undertake the defective works. So we're talking about a contra charge situation. We obviously have to be aware as well that where the Construction Act applies, then you would need a valid payment notice, PLS notice, to deduct that contra charge. In my experience, contra charges for defective works are often unsuccessful in adjudication proceedings. The reason for that is, well, a number of different reasons. Sometimes it's because the contractor was not afforded the opportunity to put right the defective works. Sometimes it's because they're just not able to prove that the works are defective and the contractor is liable for those defects. Often it comes down to quantum in terms of failure to prove the loss. And also in main contracts and subcontracts, there's often a reference to set off of bona fide estimates, but that is often abused. And when, say, for example, a matter goes to adjudication on true value, it's often the case that those values for contra charges are not really bona fide estimates at all, but are very much say figures, and therefore the case fails on those grounds as well. Abatement is really just a deduction in the value rather than a set off. So different rules apply and you have a common law right to abate. And there's 7 principles that were set down in respect to abatement by Justice Jackson in Multiplex v Cleveland Bridge. And in a contract for the provision of labour and materials, if the performance is defective, then you are entitled to abate the value. And the measure of the abatement is the amount by which the product of the endeavours has been diminished in value as a result of that defective performance. But how you then measure that abatement will depend on the facts and circumstances in each case. Is it market value, or is it the cost of rectification in terms of abatement? What could it, what will it be? So if we just move on to the next slide. So he picks up that point in item 4, and he says in some cases diminution in value may be determined by market value, or it could be the cost of remedial works. However, if it is the cost of remedial works, then that is not the diminution in value, which is kind of an interesting point. And what he meant by that is in the Cleveland Bridge case, Cleveland Bridge were the subcontractor and Multiplex were the main contractor. And in those circumstances, Multiplex don't own the asset. The value to them is actually having the repairs rectified. So in that situation, the rectification, the cost of rectification was the value of the abatement in that case. But in another situation where the employer owns the asset and rectification costs are not appropriate, then some kind of market valuation would need to be done. So obviously that in reference to abatement, what we're really talking about here is what is the amount due rather than the amount that should be set off. And therefore, in that context, it's usually the case that, certainly in terms of Construction Act matters, that the abatement should be addressed in the payment notice and not dealt with in the withholding, in the PLS. Again, many adjudication proceedings fail on abatements in value because they fail to prove that the works are defective and the contractor is liable, and more importantly and more often, they fail to properly assess the diminution in value. Okay, just finally, just want to touch on limitation periods. I mean, my advice on this would obviously be to discuss the matter with your legal team and your lawyers if you feel that there's a potential issue in terms of limitation. Under contract, it's normally we're looking at the Limitations Act, which is 6 years as a limitations period under a simple contract and 12 years under deed. And the big issue for contractors and employers is the difference between different parties in their contracts, because from a main contractor's perspective, he may well be in a contract under a deed, but his subcontractors and suppliers may well be under simple contracts. So his limitation period could potentially be longer than his supply chain. And obviously from a legal perspective, there may well be requirements to consider Latent Defects Act and Defective Premises Act as well. So after that now, I'd just like to hand back to you and to conclude the presentation. Thank you.
Thanks very much, Damien. So we've talked at some length about how defects are dealt with in construction contracts. It inevitably begs the question, how should they best be avoided? A massive subject in itself, and clearly we've got 10 minutes left at the end of the talk, so I'm going to have to be brief in what I say about it. There's no straightforward answer, but what I've attempted to do is give some guidance, and I prepared my own top 10 list of dispute avoidance, a pick of the pops of defect avoidance, if you will. And if you didn't get that reference, then you're obviously far too young. So, first of all, allow adequate time and money for design. I once went to a seminar given by Tony Bingham, who many of you will know as a barrister, arbitrator and adjudicator. He also writes a well-known column for Building Magazine, and he said it's the most common question he's asked as to how parties might avoid claims in building contracts. And he said, what to do first of all is make sure that your design team have been given adequate time and money to actually design the building. If you rush them and you don't pay them enough money, don't be surprised if they get it wrong. However, if you do give them enough time and money and they get it wrong, that's a different matter. That's when you then start to think about claims against your design team. But as I say, don't be surprised if you rush them, you don't get the service that you thought you might get. Similarly, allow adequate time and money for construction. It seems to be one of life's rules that employers want buildings faster and cheaper every time. Is it really the correct way to procure buildings? Well, as an architect, I've lost count of the number of times that I've seen contractors being pressurised into accepting unachievable construction programmes at minimal margins, simply to win a project and get that job on the order books. They do that in the hope that they can claw back time and money later on in the project, and that's rarely the case in my experience. Again, where construction is underfunded and carried out too quickly, defects are, in my opinion, inevitable. One way to address this: don't always choose the lowest tender. I have said this, I don't know how many times in my professional life to clients, and I don't think I have once been taken up on the offer. Ever the optimist, I do live in hope though. I kind of pose this question for discussion really is in assessing tenders, would it be better to use median prices or quality criteria, which will ultimately offer better long-term value to employers with a reduction in the number of construction defects? Food for thought. Number 4 on my list is implement proper project management. And what I mean by that is don't hand control to the main contractor and then expect them to act in the best interest of the employer. Particularly the case when you've just tried to beat them down with price and you've got them to agree to a shorter programme. A proper project manager must be fully aware of the exacting requirements of the construction contract and be prepared to achieve them. Too many times I've seen project managers who compromise on quality in the interest of achieving the programme. And I think that if you do that, if a project manager does that, then that is shortchanging the client ultimately, and it results in both patent and latent defects. I refer you back to some of the projects that I mentioned at the very start. I think some of those defects could have been avoided by better project management. Next on the list is clear and comprehensive appointment and contract documents from the outset. So the documents need to be clear, comprehensive and complete. Time needs to be given to preparing the documents rather than cobbling them together at the last minute. And I mean, really, an experienced contractor will be able to rely on gaps or deficiencies in contract documents to justify substandard design and construction. I've seen it time and time again. Get the documents in place before work starts, while everyone's still speaking and while it's still a desire to do so. Main contractors, get your subcontracts in order. Don't rely on previous good experience with your supply chain to carry you through the next job. And I don't know quite why I put this at number 6 in the list, because it should probably be much higher up. Be judicious about the use of contractors' design portions. There is an absolute proliferation of contractors' design portions in the construction industry at the moment, and it seems to be growing exponentially. And this is showing up in a number of disputes which HKA deal with, which are related to CDPs. I guess that the reason for that is because designers are being paid lower fees and are looking to get rid of both the design work and the financial risk attached to design work. But I would say, you know, if you're a client commissioning a bit of work, you might want to ask yourself, you appointed a design team for a particular reason to design your building. Are you really happy for them to pass the responsibility on to someone else who might have very little interest in the quality of work, and their main interest and their main focus might be profit? Staying on costs, exercise caution when undertaking potentially misdirected value engineering. When is a cost saving not a cost saving? When it costs you more in the long term. I go back to the DG1 project, which I cited at the start of the presentation. A £17 million building ended up costing £33 million, along with a lot of pain and heartache, and the building wasn't in operation for a good number of years. So was that value engineering really worthwhile? Sometimes you just got to accept that a particular standard of building, a certain size of building, and a certain type of design will cost a certain amount of money. If you go below that, you won't get what you want. You're going to have to compromise on something. Number 8 on the list is third-party checking of design, and that includes contractors' design portions. Most contracts now involve some type of contractor design work, either because it's a design and build contract itself or because the CDPs have been used. So who's checking that design on behalf of the employer? If the design team's been novated then the contractor's lost his primary source of advice. And in such cases, I think the employer should give serious consideration to employing a shadow design team to provide the necessary advice. But it's not only important to the employer to have designs vetted properly, it's also in the contractor's interest to do so as well. Remember, he's going to be hit for any of the defects that are associated with that work. So he needs to make sure that he's operating properly and getting, if it's an novated design team, getting them to check design information properly for compliance with the contract documents. Number 9 on the list, third-party checking of construction. For example, using a clerk of works. In the Edinburgh Schools and DG1 reports, which I mentioned at the start, Professor Cole suggested that one way of avoiding defects was to ensure proper checking of works on site. So you can either do that by a clerk of works, as I've already mentioned, or by employer retained consultants, such as architects, structural engineers, etc. The whole suite of disciplines retained by the employer. And go back to clerk of works, so it amazes me that for a relatively modest sum, the cost of employing a clerk of works, employers seem reluctant to use them. So some of the defects that I look at on a day-to-day basis would have been picked up by a competent clerk of works during the construction phase. And so at the risk of talking myself out of work, I'm firmly of the opinion that employers should use clerk of works as an additional insurance policy on their projects. Finally, don't rely on building inspectors to carry out inspections and monitor the standard of work. That's not their job. Don't be fooled into thinking that approved inspectors, or local authorities as it would be in Scotland, provide an additional level of protection for employers against building defects. Generally speaking, they don't. There are relatively narrow circumstances where a tortious or delictual claim can be brought against an inspector, whether they're employed privately or through a local authority. And that was demonstrated in the recent Court of Appeal case of Herons Court v Herons Lee. So that's the defect side of it, and we're now kind of looking at the forensic part of it. What happens, if defects have happened? Very often that'll require a technical expert to become involved. So hopefully be aware, HK is a provider of technical experts for construction disputes and advisory work across a full range of disciplines. And I'm sure that many in the audience, particularly the lawyers, will already be familiar with the use of technical experts. But for anyone who isn't, I'm going to very, very quickly look at the role of technical experts in construction disputes, and if we've got time, which I suspect we may not, a few case studies. So one slide on the role of the technical expert. Why use an expert? Well, they should allow the merits of any case to be assessed at the earliest possible stage, and thereafter they should assist the lawyers in preparing or defending a claim. The reason why the courts or why expert witnesses are used is to give evidence because the court doesn't know or understand matters within certain fields. In other words, it needs the help of an expert to understand the case. An expert will normally be entitled to give evidence because of qualifications and experience in a particular field. However, the expert should be expected to answer questions about their experience and also explain why their experience is relevant to a particular case. An expert gives evidence of both fact and opinion, but the opinion must always be based on fact. So in any report or any written work that an expert prepares, they must state the facts on which that opinion is based. They must be clear in the separation of facts and opinion. And as I say, any opinions must be firmly based in fact. There are strict rules about governing the behaviour of experts, many of which arise from the commonly known Icarian reefer case, and which are now formalised in the Civil Procedural Rules, Part 35, or CPR 35. I think it's important to remember that an expert owes a primary duty to the court, not the client or instructing solicitor. An expert is not a hired gun. An expert will normally be appointed by either a solicitor or in-house counsel in order to preserve legal privilege, and he must be objective at all times, not partisan. And a key skill of a technical expert should be to explain complex technical issues in plain language. I put this one at the bottom in bold so that there's no surprises to anyone, but be aware that the expert might not give you the answer that you were hoping for. They're, as I said before, they're objective, not partisan. So they should assess the facts of the case and give you an objective answer, whatever that answer may be. So at whirlwind pace, I'm going to give you an example of the work of an expert witness and how it relates to, kind of ties together some of the threads of what we've been talking about earlier. And I've kind of categorised the case studies. There's 3 of them as small, medium and large. So the small one is single discipline. And I mentioned earlier the difference between patent and latent defects. Well, that was the exact issue that was considered in this case, which concerned heat-soaked glass. It was an existing office building in London, which was refurbished to form the headquarters for a well-known company. And at the end of the rectification period, there was a dispute between the employer and the contractor, which was eventually resolved by a cash payment and a settlement agreement. The significant thing was that the settlement agreement prevented any claims for defects apart from latent defects. So shortly after that settlement agreement was signed, large planes of toughened glass spontaneously broke, showering glass onto the street below. Thankfully, given the time of day, no one was hurt. The building contracted a requirement for the glass to be heat soaked, which is a specialist treatment that removes impurities from the glass and prevents spontaneous breakage. And it transpired that the glass hadn't been heat soaked. So the issue was whether the non-heat soaked glass was a patent or a latent defect. In other words, was it readily discoverable by a reasonably competent architect that the glass was not heat soaked? If so, the building owner might be entitled to claim damages. So was it a straightforward dispute? Well, some of the factors that had to be considered by the expert were that heat soaked glass looks and feels the same as normal glass. So was it a patent or a latent defect? Was it really detectable? Although heat soaked glass is kite marked, some of those kite marks were concealed by the adjoining construction, such as floors and ceilings, as well as manifestations, which are as a decorative film applied to glass. And even then, would an architect of ordinary competence who doesn't possess specialised knowledge in the field of glass, would they have known what a kite mark looked like? So what HKA was required to do, this is ongoing litigation, but we're asked as an architect to provide opinion on what an architect of ordinary competence would have been expected to find when they inspected the glass on site. Case study 2 is a small multidisciplinary case. I say small multidisciplinary, it means there's a small number of experts involved from the HKA team. It's actually a number of projects really, because they all arise from post-Grenfell cladding disputes, and they range anything really from £1 million up to £60 million. The key points in the disputes tend to be, was the cladding compliant at the time of construction, and did the designers exercise reasonable skill and care? What's interesting from an expert's point of view is that very often the disputes start off as one thing, you know, did the cladding comply, and then they morph into something entirely different. Was it built properly? Were there cavity barriers and cavity closers? And if there were they the correct type and were they installed properly? But on top of that, there's also the question of, even if it wasn't built properly, did the government legislation that was brought in after Grenfell mean that, irrespective of any defective construction, would the cladding have had to have been removed in any case? Some of these cases that we've looked at are, some of them are in litigation, some of them are in adjudication. And I think that one of the benefits that we have as a team is that we can, especially in adjudications which are fast moving, fast paced, we can bring in experts as we need to try and meet the demands of the timescales that are set for us. And finally, the last of the case studies is a large multidisciplinary dispute. And in terms of expert services, this is probably about as large and complex as it gets. In this case, it was a new liquefied natural gas facility in international waters. And the dispute itself was in excess of £130 million. And I think actually it's multiples of that have been very conservative. And you can see there the number of different experts that were involved. That went to an international arbitration. We're currently waiting for the arbitral award. I don't really think there's nothing really that I can talk about in terms of technicalities of it, because it's such a vast dispute. But it's just to give an idea of the scale of things of disputes that experts will be asked to opine on. And I think in this particular instance, we had a team in excess of 10 experts who, although they were all providing independent opinion, both the tribunal and the client was delighted about the fact that there was a kind of coordinated approach which allowed us to address the issues in a more coordinated way than the other parties to the dispute. So that gives you an idea of what experts do and how they might be deployed in construction disputes. I think I'm looking at the time and it's 2:05, so we're 5 minutes over our time. I think we can open it up to some questions if that would be of interest to anyone. Otherwise, I think the better thing to do might be for you to write in with your questions, and we can give you written answers and distribute them along with copies of the presentation itself. And if there's nothing else, I'll say thank you very much, everyone, for their attendance.
Thank you.